In this unit, we're going to cover financing motor vehicles. We will first cover the state finance laws, then we're going to cover the federal finance laws out of Washington. Financing statistics in this industry have shown if a dealer has the ability to offer some type of financing options for your customer, you will probably sell a much higher number of vehicles. There are basically two different types of financing that you can offer your customers. You can offer that on-the-spot financing or buy here, pay here financing. On-the-spot financing is that term that you use when you have a relationship with a third-party lender through a software program. And when your customer wants to purchase a vehicle, you basically type in their name and birth date, and those third-party lenders through that software will input your information, and then they will process that application and hopefully approve that lending on the spot. And this is where the term on-the-spot lending actually originated. So if that third-party lender approves your customer's loan, the customer is going to make that payments to the third-party lender, and the third-party lender is going to wire transfer that purchase price into your account, normally within 1 or 2 business days. And if your customer unfortunately stops making payments, then that third-party lender is going to go out and hire that recovery company to do that repossession. Now, you may have already started or possibly are considering the option of starting a buy here, pay here dealership, which obviously operates a little bit differently. If you do choose to become a buy here, pay here dealership, you're going to buy that vehicle at a dealer auction, sell it directly to the customer, with the customers making payments directly to your dealership. Regardless of the type of financing you may offer, if you offer any type of financing or simply assist your customer in gaining a loan for a vehicle that you're selling, you are going to be recognized as a loan broker. And brokering loans is going to require you follow several state and federal laws. I also want you to be aware there's a lot of software programs out there that will do your financing for you, and I've done some reviews on software. If you go to the georgiadealer.com website, just click on that videos link and scroll down towards the bottom, and I review some software programs that will do all your financing for you. It's going to run your buy here, pay here dealership. It even allows you to sell your loan portfolios. It does vehicle pricing, vehicle history reports. It'll show you what vehicle is at every auction. So take a look at that if you're interested in some software programs. Some of these latest state-of-the-art software programs will find loans for any customer and also manage your buy here, pay here dealership, allow you to sell loan portfolios, and they interconnect with electronic title registration. So it's all bundled up basically in the same software program. So if you're not using any of those programs, definitely take a look at that. First, I want to cover some of the Georgia laws that affect financing, and then we're going to cover some of the federal finance laws as well. The first law you need to be aware of regarding financing is going to be the Georgia Motor Vehicle Sales Finance Act. Georgia law is very clear. Georgia law requires all retail installment contracts to be in writing. A retail installment contract shall be in writing and shall be signed by both the buyer and the seller. It has to be completed, and all the essential provisions have to be completed and signed by the buyer. As a reminder, an installment contract is normally going to contain all the information regarding the financing, such as when the payments are due, when the note would go into default, and say, for example, when a repossession might have to take place. A dealer must present a completed copy of the installment contract to the buyer at the time it is signed by the buyer. I want you to be very aware, if you do not provide a copy to your buyer can receive a refund of all payments made. So as a reminder, we make 2 copies of every document. 1 copy is going to go to the buyer, and 1 stays in your records, and we normally refer to that as the deal jacket. You must also ensure the installment contract has a space for the buyer to sign stating that they have received a copy of the installment contract. If you're using a third-party lender or software program, be sure the paperwork that you're using is compliant with all Georgia laws in addition to all federal laws. And if you're operating a buy here, pay here dealership, be sure the documents that have been completed through your software program or possibly by an attorney are also compliant with all Georgia and federal laws. I want you to also be very clear. All Georgia installment contracts must contain the following information, which is called the notice to the buyer. Do not sign this contract before you read it or if it contains any blank spaces. It must also state that you are entitled to an exact copy of the contract you sign. So make sure you have that required declaration on your installment contract. Remember, Georgia law requires the customer is given copies of all finance documents and will normally be asked to sign a document stating that they have received copies of all those documents as well. Before I talk about the federal finance laws, I want you to be aware that federal law does what we say supersede state law. So although we are following all the state laws that come out of Atlanta, we're also following some of the stricter federal laws that come out of Washington, and there tends to be many more federal laws that involve financing than there are actually state laws. And I'm going to cover some of those with you right now, including the Truth in Lending Act, the Equal Credit Opportunity Act, and the Gramm-Leach-Bliley Privacy Act. Let's go ahead and get started with the Federal Truth in Lending Act. The Truth in Lending Act requires you disclose all credit terms in writing and must disclose the following information in writing to any customer that's applying for a loan. You must disclose in writing the length of the time of the loan, the amount financed, all finance charges, a schedule of the payments, the identity of the creditor, a clear itemization of the amount financed, the annual percentage rate, including applicable variable rate disclosures, a total of the payments, the payment schedule, and also any prepayment or late payment penalty fees if it is applicable to that transaction, which would include total sales cost, demand feature, security interest, insurance, required deposits, and any references to contracts. So here on the screen, you're going to see that Truth in Lending Act disclosure that I'm sure your financing software is printing up for you. As you can see, the required disclosure has the annual percentage rate there, the finance charge, the amount financed, the total of all the payments, and the total sales price, along with all the other legalese. Remember, this is a federal law. You've got to make sure that you're disclosing all information that you see on your screen there. Make sure this is being printed up by your software programmer. If for some reason you're not using software to do your buy here, pay here, I'm sure that your attorney has probably provided you with that document. But when you do take a look at some of those software programs that I've reviewed at the GeorgiaDealer.com website, I'm fairly confident that they're going to keep you compliant not only with the state laws out of Atlanta, but also those federal lending laws out of Washington. Next, let's cover the Equal Credit Opportunity Act. The Equal Credit Opportunity Act. When helping your customers gain financing, you've got to follow the Federal Equal Credit Opportunity Act, and this just ensures that all consumers are given an equal chance to obtain credit. So there's some factors such as expenses, debt, and credit history are still taken into consideration when approving or disapproving credit. Anyone involved in the granting of credit, such as a licensed Georgia motor vehicle dealer who arranged financing through third-party lenders, or any dealer in a state that's offering buy here, pay here financing, and motor vehicle dealers acting as a lien holder on behalf of the financed motor vehicle must follow the Equal Credit Opportunity Act. This just ensures that all consumers are given an equal chance to obtain credit. So here are some prohibitions that I want to make sure that you're aware of. As a creditor or financing dealer, you're the creditor, you may not discourage your customers from renewing their credit or applying for credit because of their sex or their marital status, their age, their race, their national origin, or because they receive public assistance. You can never ever ask your customers to reveal their sex or their race or their national origin or their religion. You can never ask customers if they're widowed or divorced. You cannot ask about marital status, so please keep that in mind. You can never request information about your customer's spouse except when the spouse is applying with the customer. The spouse would be allowed to use that account as well. I want you to be aware you can never, ever ask a customer during a loan application interview if they receive child support. That's a violation of the law. You can ask them if they receive other income, but you can never ask them if they receive child support. You can never ask your customer about plans for having or raising children. So you could just be having a casual conversation with a couple applying for a loan. If you asked them if they were thinking about starting a family, they would have legal recourse against you because you would have been in violation of that law. You cannot ask them if they receive alimony, so do please keep that in mind. You can also never consider whether your customer has a telephone listing, so that's something that you definitely want to be aware of. And when evaluating, you could never refuse to consider public assistance income the same way as any other income. And I want to concentrate on this for just a moment. Let's say you are a buy here, pay here dealer, and you have a couple of different customers, and you're trying to decide whether or not to grant their loan. Well, let's just say, for example, you've got one customer that makes let's say $1,000 a month working at some job. And then you have another customer that makes $1,000 a month from some type of government public assistance program. You have to determine those incomes identically. We, as buy here, pay here dealers, could never, ever differentiate between employment income and public assistance income. Also, you can never assume that a woman of childbearing age will stop working to raise children. Or you can also never refuse income because it's part-time or pension or annuity. Those cannot be denied as well, okay? They have to be evaluated just like regular income. So please do keep that in mind. You know, a creditor's got to let the customer why their application was rejected. So hopefully your software program's doing that for you, but you always have to notify a customer if their credit application was rejected. And I'm hoping that your third-party finance company will cover that for you. But if you are a buy here, pay here dealer, I don't know many buy here, pay here dealers that reject financing, because I think we'll probably finance just about anybody. But make sure that you let your customer know why an application was rejected within 60 days. Acceptable reasons for rejecting a credited application could be reasons like your income was too low or that they haven't been employed long enough. But you couldn't say something like you didn't meet enough minimum standards or you didn't receive enough points on our personal dealer credit scoring system. It has to be very specific and cannot be indefinite or vague. You've got to be very specific on why you actually discarded that person's loan. When you send an individual's application for financing to a third-party finance provider, that lender can give you that information about why that loan was denied, so you can give that information to the applicant. Always remember the Equal Credit Opportunity Act permits a creditor, and that's any buy here, pay here lender or software provider lender, to disclose the reasons for taking any type of declination on that credit application. Now, I want you to be very aware, before we move on to the next screenshot here, credit applicants that have been denied equal lending opportunities under the Equal Credit Opportunity Act may recover punitive damages from your dealership for up to $500,000. Okay, so I want to make sure that you're very clear on that. They can recover damages from you for up to $500,000. So compliance, compliance, compliance. It is definitely the name of the game here when we are talking about these federal lending laws out of Washington. Now, the computer programs that I've evaluated on the website there, they have the same specific questions that you're going to ask the customer. So if you're reading them off the computer screen, stay on those screen questions. Those questions will ask customer how long they've been employed, ask customer what their total monthly household income is. You don't want to reach around a computer screen during a loan application and ask someone if they're married or something like that. So I'm going to recommend that when you boot up one of those lending applications, just let your customer fill out the deal. You can either turn that computer around, let them fill it out, or get up out of your seat and let them sit down and fill out their own credit application. That's going to prohibit you from accidentally asking an illegal question. And it's also going to free you up to do a little bit of paperwork. So keep this in mind. And before we move on from this little portion here, I want to make sure that you're aware that you do have the opportunity to become your own buy here, pay here dealer. And many software programs that I've evaluated will run a buy here, pay here dealership for you, which can be very, very profitable. And obviously, if you're not operating as a buy here, pay here dealer, I always recommend that you might explore this, because if you think about how a buy here, pay here model works, you can see that snowball effect of cash flow from multiple customers making payments. And if you're still just waiting on customers to write you checks, you're a buy here, pay here dealer, and you're waiting on those customers to write checks every month, and you're calling 90% of your customers to get those checks in. Some of those software programs I've evaluated, in fact, all of them will actually have an automatic payment deduction from a customer's checking account. And many of our customers now want their payments to be made on their credit card so they can build points. So that's something you want to think about. On a side note, I was listening to a podcast recently, and they were interviewing a buy here, pay here dealer that started his dealership 3 years ago, started a buy here, pay here dealership, and he built that into 1,800 accounts. Well, got 1,800 customers out there making payments every month. I did a little bit of just simple math, and this dealer that started 3 years ago, a buy here, pay here dealership, is grossing around $500,000 every single month. So it's definitely something you want to look into. I always strongly encourage you to consider doing some buy here, pay here. It can be extremely profitable, but make sure you're either doing it with legal advice or a good, solid software program to keep you compliant. Next, the Gramm-Leach-Bliley Privacy Act. This law has recently changed, and I want to talk to you about that. You probably recall the Gramm-Leach-Bliley Privacy Act includes provisions to protect consumers' personal financial information that's held by financial institutions and licensed motor vehicle dealers. These regulations are going to apply not only to banks and companies that provide types of financial products, but also to any motor vehicle dealer that's assisting with financing. I want you to be very aware that we have to basically be aware there are three parts to the Gramm-Leach-Bliley privacy requirements. The first is going to be the financial rule, then the safeguards rule, and then the pre-texting and financial privacy rule. First of all, the financial privacy rule governs the collection and disclosure of customers' personal financial information by financial institutions such as licensed motor vehicle dealers. It requires dealers to give their customers a privacy notice that explains the financial institution's information collection and sharing practices. So in turn, customers have the right to limit some of that sharing of their information. The safeguards rule requires financial institutions such as licensed motor vehicle dealers to protect the confidentiality and integrity of the personal consumer's information. You must be able to protect your customer's information, whether it's stored like on hard paper or like a digital hard drive. Hard paper files are going to need to be stored in some type of lockable type of paper storage system, like a file cabinet. And any computer that you're using to store customer loan application information must have the latest firewall or virus protection. And hopefully that'll keep like a hacker from coming across the internet and grabbing your customer's financial docs. It's kind of some common sense things here. You don't want to print up one customer's loan application and leave it out on the desk so the next customer can walk by and see that. Let's secure that information in a locked file cabinet. Make sure your computers are secure as well. I want you to be very aware. The Federal Trade Commission has recently approved a new amendment to the safeguards rule that requires non-banking financial institutions such as motor vehicle dealers and payday lenders to develop and maintain a comprehensive security program to keep their customers safe. This amendment requires motor vehicle dealers to notify the Federal Trade Commission as soon as possible and no later than 30 days after the discovery of a security breach involving the security breach of at least 500 consumers. It also requires you develop a plan, like you see on the screen here, to ensure your customer's financial privacy is protected. So you have to designate what's known as a qualified individual to oversee that security program. You've got to develop a written risk assessment and create a document that assesses potential risks to information and help develop protective measures to fight identity theft and things like that. If you have any questions on this, you can actually go to Google and just search for a safeguards rule written risk assessment. I want to tell you that one more time. That's kind of a mouthful there. Go to Google or your favorite search engine and search for safeguards rule written risk assessment sample, and you should be able to find a good sample document that you can draw up that's going to keep you in compliant. You're going to have to restrict access to sensitive customer information to only those individuals, such as employees or salespersons, who require it for their employment responsibilities as an employee of your dealership. You got to encrypt all sensitive information. You do have to train your security personnel. You could have one person as your designated qualified individual in your dealership, and then you do have to provide training to all employees regarding information security and their awareness and handling of security-related tasks, such as maybe the storage of a customer's financial documents. So keep that in mind. This is a brand new amendment to the FTC law that every dealer needs to be aware of. These practices will help protect consumer data, and they are 100% written in federal law. Now let's talk about the pretexting provision. Kind of some ethical guidelines for you here. The pretexting provisions of the Gramm-Leach-Bliley Privacy Act prohibit pretexting, or what's known as the use of false pretenses, including fraudulent statements to obtain a consumer's personal financial information, such as bank balances. So you can never use false pretenses or the use of any fraudulent statements to get a hold of your customers' bank balances. I'm sure that you're not going to be doing that, but there are, believe it or not, some unethical parties that have dealer's licenses that could possibly attempt to do something like that. The privacy notice. I want to talk about a very important part of every motor vehicle transaction that involves financing, and that's known as your privacy notice. This law was created under the Gramm-Leach-Bliley Privacy Act, and it is enforced by the Federal Trade Commission. The FTC has developed these additional guidelines to help auto dealers comply with this act, and they basically show how the privacy rule applies to specific situations that automobile dealers may face. So this privacy rule applies to any motor vehicle dealer that extends credits to someone for for example, a retail installment contract in connection with the purchase of a vehicle. Or if you arrange for someone to finance or lease a vehicle, that's going to cover you. Or if you provide financial advice or counseling. So if you're helping your customer get a loan, you are basically counseling that individual. If you engage in any of those activities, then any personal information that you collect must be covered by the privacy rule. So examples of personal information would include somebody's name, address, phone number, or other information that could be used to identify them in connection with the potential financing or leasing of a car, even if that person does not fill out a formal application. So it applies when a dealer obtains a name, address, or even a phone number, even though that customer has not filled out any type of formal application, such as a vehicle loan application. It does not apply to a dealer if a person buys a car with cash or arranges financing on their own through another lender that's not related to your dealership. So please keep that in mind. It does not apply to cash purchases, or if somebody went to their own bank and brought in a check, it doesn't apply to that transaction as well. But in the transactions that it does, you need to provide that privacy notice. Even when a loan is provided by a third-party financing company or on all buy here, pay here transactions, you need to make sure that you do have that privacy notice. Once again, we need to determine when a dealer is required to provide that privacy notice. You do not need to give a privacy notice to someone who simply expresses an interest in buying a car from you or is just asking general questions about financing or leasing. However, if a person gives you personal information in connection with a potential transaction, even without completing a formal application, let's say, for example, they give you personal information to get a quote on a financial package, the privacy disclosure is required. So you will need to determine whether or not the customer is going to be a consumer or a customer, and there's a big difference between the two. A person becomes a consumer when he or she gives you personal information in the context of possibly financing or leasing a car from you, such as maybe running a quick credit check. You'll need to give them a privacy notice. Say, for example, if you intend to disclose their personal information to a credit bureau. If someone enters into a contract with you to buy a car and you extend them credit or arrange for someone else to extend credit, then they become your customer. In the leasing context, once someone enters into a lease agreement, then they become a customer as well. Whether leasing or arranging credit, you must give them a privacy notice no later than the time of them signing a retail contract. Okay, so do please keep that in mind. Third-party financing, you must give the customer a privacy notice no later than when that customer is signing the contract, even if you intend to assign the contract to a third party. Once the loan is assigned to your third-party lender, your customer becomes the third-party lender customer, and at that time, then the third-party lender would need to comply with that law. So here's a sample privacy notification for you. You can always go to Google and search for FTC sample fillable privacy notice, and there's that privacy notice that you see right here. And this should be printed up by any type of software program that you're using. But if for some reason you're not, you could Google that and get you a sample policy. Here you see that FTC privacy notice. You're going to enter your dealership name at the very top and any type of information regarding the customer's name and address. And then there's also going to be a second page here where you're going to enter your dealership name again. And then you'll need to clarify the information that you might be sharing with a third-party lender, such as a Social Security number or any additional information. So please keep that in mind, okay? We are going to cover some other Federal Trade Commission guidelines later on in your dealer training course. But remember, basically, the only time you do not provide a privacy notice is when you have sold a vehicle for cash or that customer has gotten their own financing before they came into your dealership. We've completed this unit, and I want you to be aware, once again, I want to remind you that you can review any of these training videos after you've completed them at georgiadealer.com. Once again, that's georgiadealer.com. Click on the video link at the top of the page. And as a side note, you can scroll down to the bottom of that page and you can read several software reviews that I've done regarding software programs that will run all of your financing for you, including running a buy here, pay here dealership for you, and it'll even help you sell your loan notes. I hope you find this information very helpful.